I always say these things can weaponize a petitioner.
Yeah.
You get a boyfriend, girlfriend that are not that the girlfriend files the order of protection against the boyfriend. She can't stand him. She gets that full order of protection. I mean, in many times, these people, it weaponizes them in the sense that, okay, now I got this piece of paper here in my pocket. I'm going to call, hey, guess what? He showed up at this party and didn't leave. He drove by my house. I saw his car drive through. I have a ring cam, and so you see all that, and it absolutely, we represent folks all the time on violating an order of protection. So that's another big reason that despite what your feelings are for the petitioner, again, you usually aren't calling our office saying, hey, I want to still talk to that person. You're fighting this thing for a number of reasons, and that's another big one, is what Chris said, is that you don't want the full order of protection entered, but you also don't want to weaponize that petitioner to make it easy for you to get arrested.
Sounds really complicated.
Yes, it can be. I mean, you get yourself entangled in one of these. I've seen it where they get the order of protection. A client gets one against them. They call us, and it's, I've represented a number of violations because he sent me a text message, and it's easy to manipulate that and to say, to make it look and appear as if that person's the one sending text. And you can get yourself in a whole web of judicial proceedings as a result of the single order of protection.
Let's say I'm the respondent. I receive I'm served an order of protection. I mean, the first thing I want to do, if I think it's not true, is contact the person that filed the order of protection.
Regardless if it's true or not true, you call our office. And you do it quickly. Too many folks wait. They don't want to look at it because it's too unpleasant, perhaps. I hear that all the time. Well, I just set it aside. I couldn't look at it. I didn't really care. She's out of my life. He's out of my life. And all of a sudden they look at it and their hearing date's 2 days away. Get calls all the time, day before, 2 days, 3 days before the hearing. So you get served, whether it's truthful, whether it's a bunch of lies, you call us, because then we can get you into our office. We can meet, discuss this, and get to work, because these cases move quickly, and you're probably, when the time you were served, you're going to have a hearing within a week to 2 weeks on that notice that you'll get.
And by hearing, he means a full-blown trial. I mean, not with a jury, but go ahead.
Yeah, the hearing is to determine whether the full order is granted, where we present evidence. And so there's a lot to do in a little bit of a time. I always tell folks, there's a lot to do, but we do this so often that we have a system in place, and we can do that. But you put yourself in a much better position by calling an attorney right away. Don't get served, put it on the coffee table for a week, and then take a peek at it, and then it's, hey, it's 6 p.m. and I got court at 9 a.m. the next day. There's some judges that won't do continuances, and that's a whole nother deal. So you get served, you call us right away, because we'll get you in our office, walk you through this process, talk about those allegations, get ourselves prepared for the hearing.